Welcome everyone to our webinar on resolving business disputes without breaking the bank. My name is Jodie Thomson. I'm a practice leader in LegalVision's disputes team. I'm also a nationally accredited mediator and able to operate and run mediations. Before we begin, a couple of quick housekeeping items. You'll receive the recording and slides in your email. You don't need to take notes. If you've got any questions for me, I'll have a section at the end where I can answer as many as I can in the time we've got available. So submit them in the Q&A box and we'll get to those at the end. And we'd be very grateful if you could complete the feedback survey after the webinar. By viewing this webinar today, you're eligible to receive a complimentary consultation with LegalVision to discuss how we can help your business. If you'd like to claim this, you can just leave your contact details in the survey that appears at the end of the webinar, or you can contact us via this website. There's a poll question just coming up for you now. We're interested to hear what you're most interested in learning about mediation for business disputes. Mediation is what I'll be really focusing on in the talk today. It's about, and let us know whether that's avoiding court through mediation, how mediation operates in business disputes, how much it costs, tips for achieving successful mediation outcomes, and if you're not sure that you're here to learn, let us know. That would be really helpful. So what I'll be covering today is essentially the big picture of how to resolve business disputes without going to court. We're looking at those out-of-court options when things are going problematically in some way with some sort of business dispute. What we call these type of processes is alternative dispute resolution. That means any way of resolving a dispute that is not going to court. I'll explain a bit more about that and how to use it. But I will be focusing, as I said, on mediation. It's one of the most popular and commonly used forms of alternative dispute resolution. I'll explain why mediation works, what the mediator's role is and what happens in a mediation, and give you some tips on how to get the best results at a mediation to assist your business. Now, I'm going to get started. How can you resolve a business dispute without going to court? A business disputes, and I'm sure I don't need to tell any of you if you've experienced any before, are very stressful. They can be costly and particularly disruptive to your business. And in our team, and what we see is a really broad range of business disputes. They can include any sort of disagreement within your business or with a party who you're in business with. Any commercial matter might be between parties to a contract, might be internally, such as a director-shareholder or a partnership dispute. There are obviously employment disputes. It might be a franchise dispute, disputes with commercial and retail landlords and tenants over a construction contract, a business sale. All those types of issues that can come up will fall into this category that need to be resolved. And you might think that your only option to resolve it, maybe you're owed some money, maybe you're being threatened by the other party, is to go to court. But there's a whole layer of ways to resolve a dispute that don't involve going to court. And I can talk you through how we get to those today. The main message, I think, is that going to court should be a last resort. It is far more difficult and expensive to use as a process than it should be for most businesses. We spend a lot of time in our team talking clients out of rushing to court and really trying to explore other ways that will more quickly and cost effectively resolve a dispute. Court proceedings in particular are exceptionally expensive, regardless of the amount or the issue in dispute. So whether or not you might, for example, have a claim that's worth $20,000, your legal costs to go all the way through court to a final hearing will be much the same as if your claim is $120,000 or significantly more. We usually say to clients that, as a very rough ballpark, but regardless of your claim amount, if you're looking at suing another party or taking another party to court, your legal costs will be in the range of at least $100,000. Very rarely are they much less if you've got lawyers involved, which you usually need to be able to run a legal process. There are some smaller issues that can be dealt with in tribunals and smaller courts. The small claims division, for example, in the local court in New South Wales, is better designed for individuals to represent themselves. But for the most part, you need lawyers to assist, and that's where those costs come in. And they're your out-of-pocket upfront costs. It's very rare these days to find in Australia a lawyer who might work on spec or on a contingency basis. There may be some, but it's very difficult. Part of the reason is court proceedings take easily 1 to 2 years and sometimes longer to resolve. So if you've got a dispute that's really damaging your business, impacting your cash flow, 1 to 2 years is too long to try and resolve it. And so that's why we look at ways to avoid court. And alternative dispute resolution, you might have heard that phrase, or you might see it referred to as ADR, is a very good option. What clients like to know then is, well, how do we use alternative dispute resolution? How do we do that? If you've got a solicitor assisting with your dispute, they'll be able to tell you all the options and guide you through it. The first thing to do is to check the contract. If you've got a dispute over a contract, it might be a supply contract, it might be a lease or a construction contract, they will often have a dispute resolution clause that sets out a framework for the parties to the contract to deal with a dispute. And often that will require the parties to have a go at some form of alternative dispute resolution, like arbitration or mediation or conciliation. Courts will often require the parties to attend mediation before trial. Maybe the parties might go to court, issue the court proceedings, but the judge will often make orders, essentially sending the parties off, usually to mediation, to try and resolve it before they go all the way to a final hearing, because it's very expensive. The smaller tribunals in many states, like NCAT or VCAT or QCAT, all have requirements for most of their matters that they hear for the parties to attempt mediation before they can even issue a claim. The other ways you can get to alternative dispute resolution is you can engage your own mediator, if that's the case, and I'll give some more information about these different types of dispute resolution next. Or you can apply for arbitration. Again, I'll give a bit more information about that. There are many organisations in some states, like small business commissions, that operate very good low-cost mediation services that businesses can go via them to assist with getting a mediation started. The main types of mediation, alternative dispute resolution that we have, as I said, mediation, that involves an independent mediator to assist the parties to facilitate a settlement. Conciliation is another word you might see that businesses will use to resolve a dispute, and that's where they have an independent conciliator or legal representatives to help resolve a dispute, maybe work through some settlement negotiations. And the other option that you would have heard of is arbitration. Arbitration's a little bit more like court. It's a bit more formal. There's an arbitrator who acts a bit more like a judge, and they will hear arguments and evidence in a little bit more like the structure that happens in court, and they'll actually make a binding decision. So it's not just up to the parties to come to their own agreement. As I said, I'm going to focus on mediation in particular. It's the most common form of alternative dispute resolution that we use and that is used across Australia, and has a really good chance of success. Anecdotally, the figure I've always been told, and I'm not sure exactly where it came from, but is about 80% of matters get a result at mediation. And that's certainly reflected in our practice. We do a lot of mediations with our clients. Absolutely, most of them settle, and I think 80% is probably a very close figure. So it's really a step worth taking. It's quick. Unlike court, as I said, which can take many, many months, often up to a year or more before you even get to trial. There's long periods of exchanging evidence and various steps to go through. Mediation is like a one-hit wonder. It's can be done in a half day, sort of 3 to 5 hours, maybe a whole day. It will never take longer than a whole day, usually because there's a structure and a momentum that happens in a mediation that really does require that quite tight, fixed time frame. Mediation's an opportunity to have all the parties in the one room, whether that's a physical room or an online room, focused on the dispute, the benefits of settling it, and really focusing on getting a result. As I said, mediations can be done online, so much more flexible than requiring everybody to turn up to court. There's a little bit of court attendances that are done online, certainly since COVID, but certainly for a hearing, the parties are nearly always required in person, so that's much more onerous. Mediations can be done with your lawyers present or on your own, depends on the type of dispute and what's appropriate. And it gives an opportunity for the parties to communicate. The main difference with mediation is that there's an independent, unbiased mediator who will guide the parties through. What does a mediator do, and how do they do that? In Australia, in order to run a legal mediation, you need to be accredited and trained, as I have been, to learn the skills and the processes and the professional obligations to be able to do this. And most important is that you're impartial. So the mediator isn't, even though you may be a lawyer, and many of them are like me, you're not acting for either party. So you can't give them advice. You can't give them any suggestions about what might be a good offer of settlement, but you can guide them through. So you can give general guidance about perhaps some issues with the dispute, challenges they might face if they go to court, and you help work through a structured process to narrow the issues in dispute is often a really important one. We often see in a dispute parties come in and they might have a shopping list of grievances and things that have really bothered them in this issue with the other side. But at the end of the day, really what they need to resolve is payment of an outstanding invoice or one particular issue. So the mediator can help work through all of that and focus on what the parties need to be able to go forward and reach an agreement that they can live with, and very importantly, not go to court. One of the most common questions that came up when I was doing my mediation training by a very experienced team of people who are mediator coaches from all the trainee mediators was, well, what happens if parties get very emotional and get very upset? And what if there are people yelling at each other and angry at each other? And how do we deal with that? And it's a very good question, and we were given some very good training to manage it. And I've certainly seen this a lot when I've been in mediations as a lawyer acting for another party. Disputes, even if they're business disputes, they are emotional, they are very stressful. It is common for parties to get emotional, to get angry, and a mediator will help guide parties through that. There are ways of doing it. There are ways of managing emotions, managing people. There's an opportunity, and I'll talk about this in a moment, to have separate breakout areas and allow emotions to calm down. But it's also an opportunity to let people talk about how this dispute has impacted them and allow the other party to hear that. And that's part of the process that can help bring parties to a result, and very much consider why settling or why reaching an agreement is a better option than paying a lot of legal fees over a long period of time and going to court and having the uncertainty of which way the court might fall. So what does mediation actually look like? And I think that it's helpful to talk about this, because if you are involved in a business dispute, or if you have been, or perhaps you've had court proceedings flagged and you may have heard mediation talked about, but you've not ever really understood what it means or what happens. So as I said, it's usually set aside for a half day or a day, which is, in my experience, most commonly more than half a day. It takes that long to get through all of the various steps. What happens in a mediation? So if you have a dispute, and there's different ways you can get into the mediation. As I said, it might be mandated in a contract, might be ordered by the court or required by the tribunal. It does require both parties to agree. So you can't force a party to mediation unless it's ordered by a court and both parties are already in those proceedings. But outside of that, both parties need to agree. So you and your solicitor will guide you through this if you have one, might suggest mediation. You're happy to give it a go, and you would propose mediation to the other side, and hopefully they would agree. Sometimes organisations like the Small Business Commission, which do a lot of mediations, will assist. You can go to the Small Business Commission, perhaps with a retail lease dispute, and you may not have got the other side's agreement yet, and the Small Business Commission will reach out and help try and facilitate and get the other party in agreement to attend. Once you've got agreement, then you might choose a mediator if you're arranging it privately. Again, a solicitor will be able to assist with this and recommend a mediator. And mediators, if it's a legal dispute, a commercial dispute, mediators will usually be current or former solicitors or barristers. So they have a lot of experience and knowledge in these type of matters and have acted for clients in these type of matters before. Once you've appointed the mediator will usually then reach out to both sides. So you'll agree on a date and a venue, whether or not that's a location perhaps in one of the solicitor's offices, or perhaps it's online. You'll agree on the date, lock the date in, and the mediator will reach out ahead of that mediation to each side to get a bit of background, get a bit of understanding of what's gone on. They might ask for copies of any relevant documents. If there are court proceedings, it might be a case of providing the court documents. If the dispute is about a contract, might be a case of asking for the contract. The other thing that can happen is, and this is pretty common in most of the commercial disputes that we do with our clients, if there are lawyers involved, they'll prepare something called a position paper. And it's really helpful as a way of setting out exactly what it says. This is our position. This is what's happened. This is our position in relation to the dispute. And this is the outcome that we would like. position papers and mediations shouldn't be lengthy and detailed in the way that court documents are, but it's just very helpful for the mediator and the other parties to really be able to see what's gone wrong here, what are we arguing about, and what might we like to get out of this. So that's a bit of preparation work beforehand. And then it's a question of turning up on the day with your solicitor if you've got one, and otherwise without solicitors, and the mediator will guide you through. The mediation itself is usually a mixture of joint sessions, so everybody on the same room sitting around a table or on the same Zoom screen if it's online, and the mediator will usually introduce the matter, talk briefly about the dispute, again reminding everyone very generally that it's that they're independent, they're not acting for either side. It's very important to be aware that mediations are confidential. They're also without prejudice, which is a legal term that we use that means that nothing that's said in that mediation can be used in any other court proceedings. So if you're in a dispute with another commercial party because they owe you some money and you have some settlement discussions and you indicate during that mediation that you'd be prepared to accept a lesser amount than the amount you're claiming, that doesn't mean that if you don't reach a settlement in the mediation, that you will be forever bound by that figure. Everything that happens within a mediation remains confidential within that space. So the mediator will introduce all of that, usually in that open session. Each side, usually the solicitors, if they're involved, will make some opening statements, and again, just set the agenda for their client's position and what's happening. And then there might be some questions, there might be some discussions. Very often the parties themselves might like an opportunity to speak. If emotions are running very high, they might prefer not to. There's no hard and fast rules and there's no hard and fast requirements. So we often have clients who say, look, it's just too stressful and emotional. I'd rather not speak. I'd rather you speak for me if I'm the solicitor acting. And, you know, that's completely fine as well. And then usually the parties will move away into breakout rooms, which can be done online. So the solicitor and the other part and your own client have an opportunity to talk about how it's going. And then the mediator might move between those breakout rooms and then help facilitate some settlement options. It depends what type of dispute it is. But for example, if it's a straight debt claim or a financial claim for some reasons, then those offers are going to be quite straightforward and they're going to be amounts of money. And look, it's a little bit of a formula in terms of putting an offer and the other side might say, no, that's too high, and making a counter offer. And within those offers going to and fro, there's a lot of guidance from the mediator, a lot of discussion about the strength or otherwise of your claim, what it might look like if you go to court, the benefits of settling and having everything resolved in one day and not needing to go through the court process. So it really can take a long time. Sometimes if parties just aren't going to be able to settle, they're not prepared to budge, they don't consider they should have to compromise in any way, then the mediator will know usually within an hour or two that it might be best to cancel the mediation or to end it with no settlement. And that's okay. It doesn't mean that there's no other opportunity to settle. We've had many matters where there might not be an agreement in the mediation itself, but afterwards the parties think about what's gone on, have a talk to their lawyer about remind me again how much these court proceedings will cost if we keep going. And they might revisit those settlement negotiations. And we often have matters that end up settling with an exchange of letters after a mediation. So there's always that opportunity as well. If you do reach a settlement during the mediation, Ideally, you're able to have that documented in a deed of settlement, which is really important in any commercial dispute, to have a legal document that binds the parties to whatever is agreed. Usually includes what we call release, which means both parties agree, this is it. This is a full and final settlement. And we agree not to make any other claims against you in relation to this dispute. And so we find in preparing for a mediation, it's a really good idea to go in with a template or a blank deed of settlement ready to fill in if we're able to get an agreement. But I've also been in mediations where that wasn't done, and you might end up literally writing things on paper if you don't have a printer handy, that the parties can sign, and then the lawyers can formalise that later. So that's if you reach a settlement, and that's very much the end of the matter, and that's a successful mediation. So how do you get the best results at mediation? As I said, there's no guarantee. There's no guarantee that you'll get a result. The difference with mediation also, I should say, is that it's not like court where there's a more clear winner and loser. And it's often the case that a successful mediation is one where both parties have a result that they can live with, but they might just feel a little bit cranky that they didn't quite get what they want. That's the result of a compromise. And it's usually, unfortunately, what settlements involve. And it's rare that one party will come away feeling as if they've really won. And it's not a perfect result in that regard, but again, it's a much better result than the stress and uncertainty of going to court. I should add, and I didn't say earlier, what does mediation cost? It very much depends on the type of mediation that you go through. If you don't have lawyers acting for you, or you want to go through mediation without lawyers, and you go through an organisation like the Small Business Commissions, I think their fees vary. But for example, usually the cost of the mediator is split equally between the parties. And I think some of those small business commissions, their mediation fees are under $1,000. So, very minimal cost compared with many, many tens of thousands of dollars for court proceedings. If you have solicitors, then you will be paying the cost of your solicitor to attend that mediation, and that might be, 4 or 5 hours or even a day, plus some preparation costs if they've had to prepare a position paper and have a conference with the mediator, and perhaps have some conferences with you to get ready and talk about settlement options. We would probably see costs of our legal costs for mediations ranging anywhere from usually about $5,000 to $10,000. There are certainly costs on either side of that. It very much depends on the type of mediation. And if you're engaging a private mediator, then costs can vary, but we would see the costs range, mediators charging anything between, say, $3,000 and up to about $8,000 for a full day. And that's a cost that's split between the parties. So on the one hand, your out-of-pocket costs might be, $8,000 to $10,000, which is no small amount for any business. That's certain, but it's a lot cheaper than going to court. $10,000 will not last very long if you've got solicitors acting in court proceedings. So that's the cost of mediation. It can vary. It can be very cheap. It can be more expensive, but it's much cheaper than going to court. Back to the tips to get the best results at mediation. Well, first of all, choose an experienced mediator. If you are in a position where you are going for a private mediator and you have some choice, if your solicitor is working for you in that regard, they will usually recommend mediators who they know, who they've worked with before or who they have referred through their own legal networks, and you'd have an opportunity to look up their background and see if they're the right person. An experienced mediator will keep emotions calm and help parties really work through that dispute in a constructive way and explore options for settlement. It really helps in a mediation to be prepared. We are often giving each other tips in my disputes team here. Whenever somebody does a mediation with a client, we always like to come back and brainstorm about what worked well. Is there anything that you'd get ready for next time? And we all agree that various preparation steps make a really big difference. Having those documents handy. If you've already made some previous settlement offers, we find it can be really helpful to have a summary or a table of the costs. So you might have a ready access to the costs of the claim, the costs to your business, the costs of going to court that your solicitor might have told you about, some ideas of settlement offers that you'd be prepared to make. It can really help to have all those numbers handy. And on that line, to think about your bottom line on settlement and compare it to the costs of going to court. We often find it takes clients a while to move to that point. And that's why the mediation process itself helps clients through, because you start out in a dispute and you're aggrieved and angry and in a completely opposite position to the other party, and you think your position is right, they think their position is right, and you don't think you should have to compromise in any way, whether or not that's paying them something or accepting a lesser amount from the other side. But when you have all these figures in front of you, it can really help to make you realise the benefits of a compromise offer. And again, solicitors, as solicitors, we can't tell you how much to settle for, because that's always going to be a commercial consideration. But we can help throw in all of the different factors that will determine whether or not, to guide you through that settlement process. We find it really helps to advise clients to keep an open mind. The number of times I've gone to mediation and we all think, well, if it's for example, a debt recovery or a commercial settlement about a particular figure, we might have an idea in our heads about where it might settle for or where it might land. And quite often different things might come up. For example, you can be very flexible with how an amount of money is paid. So you might, instead of insisting that an amount is paid on the spot, you might be prepared to have that paid by instalments over a period of time. You might be prepared to have a piece of property exchanged instead of part payment. There are no rules about what's on the table. And we've seen some really great creative outcomes that when they're put forward as a settlement option and the other party says, well, actually, that would make a real difference. And lots of different options. It might be a sale of business dispute, and it might be a party preparing to add some extra assets to the sale that they weren't on the table before. So keep an open mind, because you just might find that win-win sweet spot that wouldn't have occurred to you was something that could resolve this matter until you all got in the same room or virtual room and had a mediator guide you through those options. But most important, as I said earlier, it's being prepared to compromise for a faster, less costly solution. That's the end of my formal information about mediation and about settling a dispute out of court. In summary, it's a very, very effective process. We do a lot more mediations than we than we spend time in court, as I said. So if you are in a dispute and your solicitor hasn't mentioned mediation as an option, certainly ask them about it. Or if you've got a potential dispute that you think mediation could help, then contact your local small business commission or have a look in your area to see if there are any options for mediation that you might be able to look at. And it's always worth giving it a go, certainly before you go to court or even before you engage solicitors if it's a dispute that can be managed that way. So I hope that's been helpful for you today. You can download our fact sheet on how to manage a business dispute, which you also might find helpful. And you might also be interested to know about our upcoming event. It's our next webinar on ESG leadership, navigating risks and opportunities for business leaders and legal counsel. And that's on next Thursday, the 26th of June. You can register on the link on the screen. Now, I'm going to have a Q&A session at the end and hopefully be able to answer some questions that you've asked about mediation and alternative dispute resolution. But before I get to those, while you submit those questions, and please do if you've got any that you'd like answered, I can take a minute to tell you about LegalVision's membership. So LegalVision offers a type of service that is unique to LegalVision by becoming a member and having unlimited access to our full team of more than 100 specialist lawyers for all of your business as usual legal needs. So it's like having your own in-house counsel for a fraction of the cost of having a permanent lawyer there. But our team can assist with unlimited document drafting and reviewing of business contracts, unlimited legal advice consultations, and unlimited domestic trademark registration and many more options, with options to purchase extra credit towards complex matters and ongoing disputes, which are charged on an hourly rates basis. So as a LegalVision member, you don't have to worry about the cost of lawyers in the same way. It's like having your own in-house counsel. So if you would like to know more about how membership or a desk extension with LegalVision can help you, then you can request a free consultation when the survey appears at the end of the webinar. So now I'm going to have a look and see if there are any questions that I have got. I haven't got anything online yet. So I can certainly cover some common questions that we see in dealing with mediation. And it is a question of what would happen at a mediation. I think I mentioned this was one of the questions that came up when I was doing my mediation training. What happens if the other party just is angry and emotional and doesn't play along and doesn't want to engage and doesn't want to make a settlement offer? And look, there's no guarantee that won't happen because you can't control how other people are going to act in a situation like this. The mediator will guide things through and will know when to make a call, whether or not to end the mediation. It really does require both parties to be engaged and prepared to explore settlement options. And so if it appears that one side isn't going to play along with that, then the mediator will terminate that mediation, and it means that you've then got the option to make settlement offers outside that particular mediation. But if that happens, look, it's not the end of the world. If it's a question of needing to go through mediation before issuing a claim in VCAT or NCAT. So for example, if you're a retail tenant and you've got a concern with your landlord, perhaps they haven't done some repairs to the building that you think are essential in order to stay at the lease, you might have tried talking to them, tried writing to them, and you want to take them to the tribunal to get an order to force them to do that, and you're required to attend mediation first. What do you do if the landlord doesn't agree to mediation? You can go to one of the small business commissions that the tribunal will refer you to first, and they will try and assist to get the other side to attend. And if they don't, they'll give you a certificate to say that you've attempted mediation, and then you can go on and go to court. So there are ways around things if the other parties don't comply. Another common question that we have, and it's a scenario that we've dealt with, is what happens if you reach an agreement during the mediation, but you don't sign an agreement on the spot for various reasons. Perhaps there hasn't been time. Perhaps the parties are agreed to leave that till afterwards. As I said, usually it is better if you can get some sort of signed agreement by the parties on the spot while they're all there. But if you can't, for some reason, we had a mediation recently where our client was a not-for-profit organisation, and they said, look, we can agree to a settlement up to a certain amount, but outside of that, we need our board's approval. So we weren't able to commit to and sign an agreement on the actual day. What happens then if the parties change their minds afterwards? Well, it can be quite complex depending on what's gone on. You will have to take advice from your solicitor about whether or not there's any way of considering or making an argument that there's a legally binding contract in place, even though the parties didn't sign it. But it may be that you just have to go back to the drawing board and start again and find out if you can get that party to agree in another way. And that might mean even going back to the drawing board and considering starting legal proceedings, and you might be able to get back to mediation after that. Another question that we deal with all the time with our clients is we will usually mention mediation when there's a dispute and if there's the possibility of court. For all the reasons I've talked about today, it can be a very effective way of resolving a dispute quickly and cost effectively. But the client might say, well, when do we go to mediation? Should we do it straight away? Should we do it after you've sent a complex solicitor's letter to the other side? And it can come down to strategy, because you want to, depending on the type of dispute, it might be better to have some sort of demands sent to the other side first. In some cases, it can be quite effective to start court proceedings. It might be that you file an initial claim or you prepare an initial claim document to show the other side that you are very serious, that you are prepared to go to court, and to set out in the very formal legal way what your legal claim might look like. And then you can go to mediation. And it can give you a bit of extra leverage if the other side knows that you're very prepared to go to court and to continue in court. If it's too early, there might not be enough emotion or enough information on the table for the parties to engage in a very serious mediation in that way. Another question that we do often see is what happens if you have an agreement and you all sign a deed of settlement, and that gets locked in, and perhaps the other party has agreed to pay you a certain sum of money by instalments. What happens if they don't pay then? Unfortunately, we do see that happen quite a lot. It's very often by that stage a question of cash flow or financial position that a company might be in. And that's why it's important to have a deed of settlement, because a deed of settlement will set out the process if the other party defaults. And usually that does mean making a court claim. You're able to make a court claim very quickly, much more quickly than if you had to get an initial determination from the court on your claim. But it is something that can happen again. It's not always possible to guarantee how the other side is going to operate. So I think that's probably the end of the questions that we've got available. Unless there are any last questions that anyone might like to put in, I can just sneak in before we finish off. But otherwise, thank you very much for attending today. Again, please submit your details if you haven't already in the survey at the end, and we can you can submit your details in the survey, and we can learn more about how our membership can help you. This is a free webinar. We very much value your feedback. So again, please complete the 30-second survey at the end. And thank you very much for joining us today. Please feel free to reach out to LegalVision if you have any type of legal dispute or need that we can help you with. Thanks very much, everybody.